Hi everyone, this is Immigration Attorney Mustafa Cetin. I'm here today to talk about the upcoming visa bulletin, especially the priority dates announced for the employment-based category. So basically, from September 2020 to October 2020, there's going to be a significant shift in the priority dates announced for employment-based categories, especially EB2 and EB3, and specifically for countries with a backlog, which are India, Mexico, and other specified countries in the visa bulletin. To be more specific, for India, EB3 category was filing date for EB3 category for September was the priority date was 2010, and for the upcoming month, October, it's going to be 2015. That would mean that those who have a pending EB3 based I-140 approval will be eligible to apply for adjustment of status in the upcoming month of October 2020. So what are the requirements for this? First of all, we need to understand this is going to be a petition, an adjustment of status petition to get a green card, to get permanent residency, based on the job, the sponsors employing. So the job offer must still be standing. The idea behind is for the applicant to get a green card, originally that employer followed the steps to certify that they need this individual, this applicant, for a specific job for which the US labor market had no one to offer. So based on that, there was a labor condition, labor certification filing, and based on that, there was an I-140 and it was approved. So that same job, that was the basis of that filing, must be standing. So for that, you would need the same employer or a successor interest to the same employer. In case of a name change or a merger, it might still qualify, but the same job must be there. Otherwise, the individual will not be able to get the green card, will not be able to adjust. And the way this is achieved when the filing is done is through a supplement to the I-485 form, which is supplement J. Basically, the original sponsor is signing off on the supplement J form and attesting that same job offer still stands. So if the applicant is still employed by the same sponsor, same employer, there is a very good chance that they might be able to move forward with this petition. But there are a few things to consider. First of all, this is an adjustment of status application, and as a general rule, to get the immigration benefit, there shouldn't be any inadmissibility concerns. There shouldn't be any criminal involvements and other stuff that could prevent someone from getting an immigration benefit. And you have to be in status to be able to file the adjustment of status application. That is a given. And one thing to also note here is when the petition is made, when the I-485 is made, the labor condition, the job description is not going to be reevaluated. But there's a possibility that the USCIS officer adjudicating, deciding on this I-485 petition, they might look back into the original labor certification and to see if there has been a material change. So the material change is a term of art here, and basically it goes back to the same idea, that is the root of the green card, the sponsor needing this individual for that specific job. And there is a possibility that if the job changed significantly in terms of the salary, in terms of location, other stuff to consider here, there could be a problem. But other than that, what if there's a different employer? You're employed by a different entity now. What are you going to do? What you can do is basically, if the original sponsor is willing to still offer the same position, they're willing to sign off on the supplement J, you can file for your I-485 petition and seek to adjust status and get your permanent residence. In this case, I should also mention something that will be kicking in with the filing of that I-485, which is job portability. Under a specific provision, if an I-485 is pending for 180 days, the individual will be able to shift from one job to another in the same occasion. And this is something to consider when you are, let's say, reaching out to your previous sponsor to discuss, because that could affect the outcome of the negotiations. How about downgrading? We get asked that a lot. Downgrading from EB2 category to EB3 category, is it possible? Should it be done? If the labor condition, the same job still stands, and the labor condition certification is valid, in that case, it might be possible for the sponsor to file an amended I-140 and at the same time concurrently file for an I-485 petition because of the new priority date that is available. In this case, the premium processing will not be available because the labor condition certification is not new, and because of that, it involves a certain risk. The category, the priority date for which is available now, the EB3, could become oversubscribed, and down the road in the couple months where this petition, the downgrading petition, the amended I-140 will be adjudicated, could be not available anymore. So if there's a problem with the I-485 petition that will be filed concurrently for downgrading with the I-140, it is advised that the individual should not lose their non-immigrant status to be able to not to prevent any future possibility of seeking another adjustment based on a different I-140. If you have any questions, and I'm sure you must have, I'm here to help guide you through this process. One thing to note here is we, as a small firm, we're better situated to react to an immediate change like this, unlike a bigger practice where things tend to move slowly. But basically, feel free to reach out. My contact information is under the video link, and we'll be happy to help you, guide you through this process. And one thing I should note is, for those with the same employer, because the application that is being filed is on the I-485, you don't need the employer to hire. The employer doesn't need to hire the immigration firm, which was the case for the I-140 and labor condition filing. The individual might hire an immigration firm, an immigration lawyer to handle this petition based on the situation, and with the company's blessing, which will be in the form of the supplement J form. Again, my contact information is down there. I'm here to help. Hopefully, many individuals that have been waiting for a very long time to get their green cards, this will be the beginning of good news and good outcomes. Thank you for listening.